From WKNOW, this is Steve Chanley with One Question Too Many. Today's program is made possible by the law firm of Employer Advocates Group, serving California employers since 2002, with offices in Orange County and San Luis Obispo County, California. eaglawgroup.com. Joining us today is Leonard, Assistant District Attorney in Chattanooga, Tennessee. He's a former Special Assistant United States Attorney for the Western District of Missouri. Mr. Miller has handled literally thousands of criminal cases, from misdemeanors to first-degree murder cases. Thanks for joining us today.
Oh, thanks for having me. It's a pleasure.
May I call you Miller?
Yeah, please.
How long have you been practicing law?
How long have I, let's see, 7 years, I believe. Long time.
What is the current nature of your practice as an assistant DA?
Currently, I'm what you would call a line assistant district attorney general, and that means that I spend my week either in criminal sessions court, which is where cases that aren't directly filed into the grand jury will begin, and then my other 2 weeks out of the month are spent in criminal court, which if you're not in a town like Memphis or Nashville or Knoxville, it's also called the circuit court. But in Chattanooga, which is the fourth largest city in Tennessee, we have 3 judges who only hear matters in criminal court that go to trial.
Can you explain those two different?
Yeah, so basically the way that Tennessee works is that there's sessions court, and then could be anything in terms of you could have a speeding ticket in your sessions court, for instance, not normally, but you could drive them all revoked. So you could have some low-level things in sessions court. You could also have in sessions court a high-level felony like murder. I've had murder cases in sessions court. And you can work out misdemeanor cases in sessions court and enter a plea, and the sessions judge could put that individual on probation. Otherwise, what sessions court serves as is a probable cause court. It's a means and mechanism to ensure that probable cause exists for that individual to be held. And be charged. You can deal with things like bond. You have contested hearings that are adversarial. And then if a case is bound over from sessions court, it will go to the grand jury, where the grand jury then will hear the case again and determine whether or not there's probable cause. And if they determine to indict you on a true bill, then you go up to, in our case, criminal court. And in cases outside of Chattanooga, Memphis, Nashville, or Knoxville, it would be circuit court.
How long have you been an assistant district attorney general?
Just about 2 years.
Immediately before that, you were in private practice?
I was in private practice for 16 or so years, both in Missouri and Colorado. Prior to my jumping into private practice, so prior to that 16 years, was a legal aid attorney, Missouri State Public Defender, a Missouri State Prosecutor, a Special Assistant United States Attorneys. Those are the government jobs I did prior to joining a couple of law firms. I was in a couple of law firms before I started my own law firm. And then primarily for the last 16 years, I have focused on criminal defense. I really liked federal criminal defense. And for about 7 years in Colorado, I was a part-time municipal judge.
Is there much of an adjustment for you going back to public service after being private practice?
No, not really. And probably the reason for that is that it's sort of like going home to what I started with. So I'm used to big dockets from being a prosecutor and public defender and legal aid and judge. Those are all big docket areas. The criminal bars in Missouri and Colorado and now in Tennessee, they're very similar. Everybody's collegial. Everybody's pretty likable, pretty nice. And so it wasn't really that big of a change in terms of overall life. There's some changes with getting used to every system has a little bit different tweaks to the law. So there's some changes there. And I mean, we're very busy in terms of busyness. Being a district attorney is far more busy than most private practitioners.
I would imagine it would come as somewhat of a relief to be liberated from the rigors and chore of managing a private practice?
Yeah, I mean, there are some good things and bad things about private practice, and as you can relate to, one of the hard things about being in private practice is that you have to market yourself and you have to run a business. And I was a solo. I never wanted to be bigger, and so all the administrative tasks would be something that I was at least going to touch, if not be outright responsible for. In terms of practicing law, being an assistant district attorney is about as pure of the practice of law as you're going to get, because our job is just to try cases and move cases and handle cases. There's no business generation requirements. We have more business than we need, and you don't have to market yourself, and you're not required to obviously bill hours or anything like that. So there's a lot of things that are really nice and fun about being an assistant district attorney.
Practice like that permits you to focus more on pure lawyering.
Yeah, it does. Even though there's a lot of pure lawyering, we have an enormous amount of contact with the public, especially in sessions court, where a lot of people will go pro se and not be represented. And then there's any case that has a victim, we're going to be talking to the victim in conjunction with our victim witness coordinators. But basically, our job is to try cases and to resolve cases and to make sure that our dockets are appropriately handled. And so in that sense, yeah, I think it is a pretty pure practice of law.
You're both a prosecutor and defense counsel in criminal cases. Do you have an affinity for one over the other?
Yeah, that's a really good question. In some ways, it probably depends on the season of my life. When I first graduated, what I really wanted to be was a defense attorney, and enjoyed it and loved it and thrived. At least I thought I thrived in it. And then there became a point where I knew that it wasn't something I wanted to do forever, in terms of I knew I didn't want to be a career public defender. And that's why I switched over to being a prosecutor in Missouri. And then after about 6 years, I went into private practice. Now, I think I prefer being an assistant district attorney, and enjoy the work, enjoy the people. I'm fortunate to work with some really fun and good lawyers. A lot of us in the office have been defense lawyers before. I think that being a defense lawyer prior to being a prosecutor is advantageous, because you understand some of the trials and difficulties that your opposing counsel may be going through. And you also understand some of the issues that defendants have in a different way. On the whole, yeah, I think I much prefer being a district attorney.
You're pretty active on LinkedIn. In fact, that's how you crossed my radar. On LinkedIn, you frequently write posts giving advice to law students. Can you tell us about that?
Sure. Yeah, that's pretty much the focus of my LinkedIn, is to talk to law students. That, and I talk about some of the ways that you can work on being a better trial attorney. I noticed when I was in law school that it just wasn't what I thought it would be. I'm more of a hands-on learner, and I found law school to be pretty book-oriented, academic, which is fine. You have to be learned in the law, but I just felt like something was missing. And when I became a public defender, one of the things that the Missouri State Public Defender System does really well is put any new attorney through mandated training. And so you go through trial skills 1, 2, and 3. I think there was a sentencing workshop. There was some other training I think that we had to go through, which I'm not recalling at the time. And then as a prosecutor, I did training out at the National Advocacy Center, which is in Columbia, South Carolina. And after those experiences, it dawned on me that there was this missing component, in my mind anyway, of law school, in that we're not giving students the opportunity to put into action what they're learning, not in a really concrete way. And so that's one of the reasons why I started talking to law students, because I figured that I couldn't be the only person who was dissatisfied with their law school experience, and wanted to try and give some hope to people who might be sitting there thinking, why did I make a mistake? Is this something that I will regret? Is the practice of law going to be like this? And so I've spent the last 3 or 4 years really focused on students and trying to help them bridge the gap between school and practice.
You graduated from law school in 1998?
Yeah, 1998, a long time ago.
Do you believe that how law is currently being taught is somehow different than it was in the past?
Well, I suppose that, to be fair, I haven't been to law school in a long time. in my conversations with our interns or folks who are in law school, I think the law is being taught similarly to how the law was taught when I was in law school. I think there's maybe a bit more emphasis on some clinics in law schools. They've developed a lot more clinical opportunities for law students. I think that some teachers have recognized that a pure dogmatic Socratic method that a lot of us dealt with isn't necessarily the best means and mechanism to teach law students. But on the whole, I think it's pretty much the same. And one of my biggest critiques and criticisms of law school is that the majority of law schools engage in grade curve or grade normalization, at least in the first year, if not further. And I think that's a distinct disservice to law students.
Law schools mandate some period of clinical experience, similar to what currently exists in medical schools?
So it's a really good question. I don't know. I think that the law schools have broad ability to control their curriculum so far as it doesn't then get them out of line with their ABA certification. And I'm not an expert in that area, so I couldn't tell you what gets somebody ABA certified or decertified. I think some schools have created curriculums that are much more clinical oriented than others. And hopefully that will continue. If it were up to me, I would design law school as like a year and a half of the book learning of the normal bar required courses, followed by a year and a half of clinical rotations.
Let's explore that a little bit. So the ABA accreditation requirements aside, if you were tasked with creating a curriculum for law schools, other than the obvious subjects that are on the bar exam, what would you include that isn't generally part of a standard curriculum?
Well, what I would like to see is the opportunity to explore various practice areas. Most law students, I think, go into law school and they have a general idea of what they think they want to do, but we're not exposed to a series of rotations like medical school, which is the best professional school example that I can think of how people get exposed to different areas of medicine. And if we translate it to law, I didn't experience wills and trusts, writing a will or a trust in law school. I was never given the opportunity to write contracts. I had a tax class, but was never given the opportunity to engage in either tax advising or tax preparation. I had criminal procedure, but didn't do the criminal law clinic. Now that was my fault. But if you think of all the different subjects that we have, oftentimes the first time that we engage them in a real way is when we start the practice. I mean, the first time I ever looked at a deed for property was when I was 7 years out of law school, working for a firm where one of the partners did a lot of real estate work. I'd never seen the deed before. I never looked at the deed in terms of how it would apply to a restrictive covenant in the case that we were dealing with. I think that's a fundamental flaw with law school, because a lot of people's ideas of what they think they want to do will not jive with the reality of what they want to do. And I can remember one of my friends who became a very good doctor. He always told me he wanted to be a neurosurgeon. And I asked him, well, he's smart. He's super smart. I'm like, why didn't you become a neurosurgeon? He said, well, when I did that rotation, when I did my surgery rotation, I realized that I was not equipped to keep the hours that surgeons keep. Good lesson.
How well do you think most law schools are in preparing their graduates to do something as basic as interacting with a client?
Poor. And if they're doing any of it at all on any sort of level that is helpful, it's coming through clinics and their adjunct professors or clinical professors.
Now, to my mind, that's just such a critical part of delivering legal services. You first have to ascertain from the client what the issue is, and why it is that they're even coming to see you. And then you have to gather quite a bit of relevant information in order to size up the situation, perform an analysis, possibly create a menu of options going forward, making a recommendation. And all of that hinges on the information that you are able to extract from your client.
Yeah, I think that's a great observation. It's fascinating to me that law schools don't do any of that basic necessary work And yet my wife, who in a prior career was a paralegal and had gone to school to be a paralegal, had specific classes on client intake. And when she went to work at firms, she would tell me that she was very prepared to engage in client intake and dealing with clients because they had worked on that in school. I didn't have any of that in school. I was never taught how to intake a client. I was never taught how to do a social background of a client, which I learned. I learned how to do that in the public defender system. They taught me how to be a holistically oriented attorney. And primarily, I think the problem and the disjunct between law schools and the practice, and why that skill set really isn't taught as well as it should be, if it's even taught at all, is because law school has become very academically focused, and the practice is a learned profession, but our clients don't want to pay for a law review article that we write. They want a solution to a problem.
Strikes me as sort of paradoxical that law students are taught the ethics of practicing law, and the ethics of practicing law by their nature require that from the outset you determine whether or not there's a potential conflict to even represent a client, but yet they don't teach you how to gather that information. Coming out of law school, I wouldn't have had any clue about those sorts of things because they were never addressed.
They weren't addressed when I was in law school. And I think in some of the clinics, maybe they were, but not in the way that it was addressed when I went to work for law firms where we were intaking lots of clients, like a legal aid and the public defender, and having to deal with all sorts of issues that were causing or interacting or going to be something that we had to deal with in the course of the lawsuit that was going on. It's unfortunate to me that law school has become, at least in my mind, so removed from the practice of law that I think a lot of people who go to law school get an incorrect idea of what being a lawyer is going to be. And I say this on my LinkedIn post a lot. I think really what law school on the whole teaches somebody to be is an appellate court clerk. But most of us
Can you elaborate on that?
Well, we're taught how to review cases. We're taught how to issue spot, issue rule analysis conclusion, or conclusion rule analysis conclusion, how to write a memo. We look at the law basically from a standpoint of a still case record, the record on appeal. We read cases where the appellate court is giving and rendering an opinion on what happened in the trial court. And so it appears like the answer was readily apparent. I mean, think about all the cases you read, and if you know anything about the case that the appellate court's talking about, you think, well, it's great that in the Mount Olympus view of the appellate court, it was so easy to see those issues. It was not if you were on the ground at the time. And so you leave law school and you view the law as this black and white academic subject, and then you go practice it with people who come to you. No matter if you're a plaintiff or defendant, you have people who have problems and they want those problems solved. And the law is a mechanism by which we solve those problems. And it's very difficult, I think, to take a case law only view of somebody's personal problem and apply it in a helpful way.
You raise a very good point that studying law with a case book, you're reading an appellate case, so the record is the record. And what is discussed is not the conflict that exists regarding what the facts really were. It's simply the application of the law to a static set of facts. And as you correctly point out, that only exists in the real world in appellate practice. Do you think law schools spend enough time on some of the practical aspects of law practice, such as the economics of it? Developing a client base and learning how to manage a law practice?
No, there are probably some that do better jobs than others. In my experience, that was not something that was talked about. Most law professors didn't practice long enough to have those experiences and understanding. You would find that in your adjuncts more than any other place. I mean, I do remember in a upper level criminal class having a criminal defense lawyer tell the class that you'd really need to make sure you get paid because you'll do better work.
Tell me if you've ever had this experience or some variation on it. Someone tells you, you're an attorney. My son or daughter wants to be an attorney. They love to argue. Do you sometimes hear that?
Oh yeah, you get that. So and so's they're great at arguing, and they love debate, and they would be a great attorney. What do you think? Yeah, I think it's common. I think it's a common misconception that all we do as attorneys is argue, and it's part of it as a trial attorney, right? But it's not everything.
My common response to that is, well, does your daughter or son like to read and write? And then the person usually has sort of a blank look on their face and like, why are you asking me that? And then I have to explain to them that, well, a great deal of what you do as an attorney is research and writing. You have to have a tool set that's quite a bit more fulsome than just the ability to argue or the inclination to argue.
And sometimes we learn this in the practice or in life. Just because you can't argue doesn't mean you should. One of the things that people who, when they say those kind of offhand comments of my child likes to argue, do you think they should be a lawyer? In some ways is asking maybe the wrong question or looking at it the wrong way. Because most of the time when people say, well, they like to argue about things that are fun or interesting to them. But the law is a conflict system. And at least in my experience, one of the reasons that people sometimes don't like being a lawyer is because of the amount of conflict that they necessarily come into in the practice. And that is, again, I think one of the big differences between the study of law and the practice of law. The study of law is to look at a problem and read a case and to debate the aspects of that case and the application of the law. The practice of law is to deal with the parties who are emotively involved, who are hurt, wounded, angry, feel that they've been mistreated, who are emotionally stressed out by going to court, who may be going through the worst thing that's ever happened to them in their life, and you have to be there with them. And nothing in reading case law will prepare you for that. And liking to argue won't prepare you for that. And so that is one of my overall problems with how we're training our lawyers and bringing them up is that we are not realistically exposing them to what the practice of law is.
You touch on the emotional aspect of conflict. Is that something that you think plays a significant role in attorney burnout?
Oh, I'm sure. I go back to early in my career and standing in a home looking at a person with their head basically severed and being able to identify on the refrigerator in front of me where their jugular vein was pumping out. That kind of stuff stays with you. And there's only so much that people have in them before they're going to really face those sort of emotive impacts of trauma. It's vicarious trauma, but the mind does a really poor job, I think, of delineating between vicarious trauma and real trauma. And if you think about what we do in the law and a lot of the areas that people practice, problems that you deal with are not pretty.
Personally found a method of compartmentalizing or somehow adjusting your view of things so that you are not worn down by the emotive parts of law practice?
Well, I mean, sometimes you just get worn down. You're just going to need to take a break. And I think that's just a reality of doing anything, is that you're going to get worn out. I'm a Christian. My faith plays a large part in being an attorney. So I realize I'm not the person in control, and I can pray for people in their hours of need or in their periods of the life when they're in need. I can turn to Jesus for strength as well. I like to work out, which is helpful. There's some things you can do, like changing the images in your head to black and white, that I think help the mind to understand that didn't happen to you. But unless you don't have emotions, it's going to affect you at some point.
Let's get back to law students. There's a lot of talk in the last 20 years about, quote unquote, today's generation. And by that, I mean generations X, Y, and Z, and how they're supposedly so different from young people of generations past. Is that your experience? Do you think that holds true for today's law students in particular?
You know, the law students that I've encountered recently, no, they seem hard. Like every other law student I've come across who's going to be successful in the practice, they're hardworking, they're eager, they are team players, they want to do the work, they're willing to put the time in, and they seem motivated to go above and beyond to learn their trade.
Because the last few generations of law students have grown up texting and with the internet, social media, and video games, things that you and I didn't grow up with. Do you think that they're perhaps more inherently attuned to new technologies and are better equipped to adapt to new technologies because of that?
Probably some. I think some of it's just because it's more intuitive to them since they grew up with it. It's a little bit easier. They certainly understand the lingo and a lot of the text easier than I might. And then maybe not as intimidated by some of the technology. Anybody who's been in practice, though, for the last 20 years, we've seen a lot of different technology changes. And it's just part of being a lawyer anymore, is that you have to deal with the changing aspects of technology, and that can be good and bad for the practice. It certainly creates a lot more evidence, a lot more places to look than we used to.
In terms of demonstrative evidence at trial, what are some of the ways that AI is currently being used?
I don't think I've seen AI used in a court case yet. I'm sure it will be in the courthouse I practice in. I don't think I have seen it used yet. I have seen some attorneys. I had one the other day who was showing me what AI had done in terms of, I think it was through Westlaw, maybe accumulating cases for him in a search. And he was speaking highly of that. But I haven't seen it in terms of demonstrative evidence or any graphics or anything like that.
I have not used this in my law practice, but I am familiar with the fact that generative AI can be used to create images and models. So I imagine that in the not too distant future, it's going to become pretty commonplace. I think that in particularly personal injury cases, possibly criminal cases, where AI generated images and models will be used to help juries understand the circumstances under which certain alleged conduct occurred. It's my practice to guess what they believe the future of AI in law practice would look like. What are your thoughts?
AI, especially as I've used AI in terms of some of the large language models, I think that's the term they use for them. It's interesting, and they're really good at bouncing ideas off of, and in ways that we didn't have before that came around. I'm sure that they'll get AI to the point where it is really good at accumulating cases that are on point. I know that's been an issue with some of the things we see in courts where lawyers get sanctioned because they use a brief that AI created, I guess, that had spoofed cases or made up cases. But I imagine that some of the companies who deal in legal research will create their own AI services that don't have that issue. There's no doubt that the graphics that you can create with AI, I mean, I've seen my son do that in some things where he shows me a picture and it was created by AI and stuff that he had typed in. And so that's going to offer us the ability to create demonstrative evidence. I suspect that AI is going to lead to more evidence that we end up having to comb through. If you think of like cell phones and all the evidence that cell phones have created for criminal cases or PI cases or any type of case, any sort of litigation case, think how much data now gets extracted from cell phones. It will definitely have an impact. I'm curious to see myself how it will. And I imagine it's going to be both good and bad, which is usually the case with technology.
I would agree with you on that. One of the very specific issues that I see coming up in the future in terms of demonstrative evidence, the use of deep fake technology to the point where it may be very hard to distinguish the authenticity of a photo or piece of video, whether it's actually depicting something that happened. What are your thoughts on that?
Well, I mean, that's an interesting question. If you want to put a photo into evidence, as you know, you have to have somebody who's going to authenticate that photo and say that it fairly and accurately depicts whatever is being discussed. And so if I have a picture of a car that I say was hit and I'm trying to show the damage, and I have to put someone on the stand who says, well, that's a picture of that car, and it's fairly and accurately depicts the damage that occurred on October 10th of 2024. So in terms of authentication, I'm not sure it changes much of anything. Most photographs, for instance, aren't self-authenticating. Can it create problems in things like creating fake text messages? I'm sure it can. Could somebody create a fake video, for instance, that purports to show somebody committing a crime? Yeah, I'm not technology savvy enough to know if that's going to be the case or not. I suspect it will. Are there going to be mechanisms by which the experts can look at the code that's behind all of that and say, yeah, but I can tell this isn't authentic? I don't know. I think it's going to create some evidentiary issues for courts. And, normally, for instance, foundational issues are not overly burdensome. And the burden to get something into evidence foundationally is often slight. And then the rest of it goes to weight or credibility. Will AI change that? Will we get courts looking at things saying, these fake images or fake videos are to a point that we're going to change what the burden of proof is to get in, let's say, an unwatched video, just a video that was, on the north side of my house, but I wasn't watching what happened. And all I can testify to is that, well, the video was playing and the video machine was working properly. Will courts say, well, I don't know, you're going to have to now prove that there wasn't some sort of generative AI involved in making that image? I don't know.
The most fascinating aspect of it is in the criminal law setting, given that the burden of proof is so high. I could see that as almost its own category of defense, that images may or may not be genuine and authentic, even though somebody may authenticate it. And that may be enough in itself to create a reasonable doubt.
Yeah, sure could be. I mean, those are things that we're no doubt going to deal with. There's somebody's going to bring a defense up that what purports to be a video of somebody committing a crime, in fact, it wasn't them. It's all made up. And when that happens, and I think all eyes will be on whatever court that case is going on in and where it's happening, because people are going to be curious to see how does the court deal with those kind of challenges.
In a way, conceptually, it's really not that different from someone is contesting a DUI or DWI, and their defense is predicated on the alleged inaccuracy of the technology that's used to measure blood alcohol level.
Yeah, I think there'll be some similarities to it. I think the rules of evidence probably can deal with it and are flexible enough to deal with the idea that this image isn't what it says it is. We've got two different realms. If there's somebody who's testifying that this image is what it is, that's different than the system that's unmonitored and supposedly captures a crime. And I don't know how the law deals with that. I think the law will deal with it like it does with most things, is that it begins to go to the weight which the fact finder has to attribute, rather than admissibility, unless you can get somebody up on the stand who can show by a preponderance of evidence proof, let's say, that this image, this video, was in fact not real.
Let me switch gears here. How important is it, do you think, for young attorneys to receive mentorship?
Well, I think it's crucial. And that's one of the reasons that I write on LinkedIn, is to encourage young attorneys and law students to get to places that are willing to train you. The practice of law is a learned profession. It's really important to go to work in a place that has structured training, and that structured training is premised on the idea that you can take the training and put it into practice. And one reason I talk a lot about public defender systems or state district attorney's offices is because the training you're offered in those groups is coupled with the fact that you're going to have a caseload that you can then go put the training you receive into practice. It's very difficult, I think, to become a competent, skilled attorney without being taught how to be a competent, skilled attorney. And you have to be taught by somebody who, in fact, is a competent, skilled attorney.
Mentoring young attorneys, something that also benefits experienced attorneys?
Oh, yeah.
Be a mentor?
Yeah, some, I should say. I think there's some folks who don't like to teach, and that's fine. That's just not their thing. But if you like to teach, and if you helping people find their potential, then mentoring and showing somebody how they can be good at what they want to be good at is quite rewarding.
So we've reached the point in our show where I'm going to ask you the inevitable question. Have you ever asked that one question too many?
Yeah, I thought about that. And then I can't recall asking that one question too many. And I don't think I have. but I certainly have seen it happen. And generally, I've seen it happen on cross-examination when an attorney asks an open-ended question rather than a proper cross-examination question, which is a statement. Or I've seen it happen when an attorney, either on direct or cross, doesn't know the answer themselves and they get burned because the answer that comes forth is damaging to their case.
Is there any example of that just jumps out at you?
I can recall a case where during cross, the defense attorney asked an expert, how did something happen? And that was the wrong question to ask.
Been speaking with Miller Leonard. Miller, can you tell our listeners how to reach you if they want to communicate with you?
Probably the easiest way to reach me is to look me up on LinkedIn and connect and send me a direct message. I am pretty good about responding to my direct messages and enjoy meeting people on LinkedIn. I like chatting with new folks, and I'm certainly more than willing to try and help somebody out on LinkedIn however I can.
It's great. Thank you again for being on our show.
Yeah, my pleasure. Thank you so much.